I'm Carole Taylor. On this edition of Journal, another hitch in the plan for a smooth path to reconciliation in British Columbia. First, we had the BC government's introduction of the Land Act, and that unsettled many with its assertion of co-management with First Nations of all the Crown land in the province. The act was withdrawn, but not before some name-calling. But then in a splashy press conference, Premier Eby announced the granting of Aboriginal title to Haida Gwaii. When people of all stripes and professions raised questions about what that would mean for private property owners, the Premier announced again and again it would not affect private property. And then, boom, there was the court decision granting Aboriginal title over land in Richmond to the Cowichan, with the judge suggesting, despite what had been asserted by Premier Eby, there were issues around private property rights. Finally, last month, in another twist on this reconciliation journey, a different judge, a separate case, found that BC's mineral claims regime, fundamental to our hope-for resurgence in mining, is inconsistent with the province's own declared law, DRIPA, the Declaration on the Rights of Indigenous Peoples, because mining claims were made before receiving free, prior, and informed consent from First Nations. With all of this cumulative confusion and uncertainty, is it any wonder that support for reconciliation has fallen in recent polls? Joining me to make sense of all of this is Thomas Isaac. As one of our country's leading experts on Aboriginal title and the law, he has concerns about what he's seeing in BC. Back in a moment. I think most people would agree that there's certainly a lot of uncertainty around the confusion on court cases and government saying one thing and judges saying something else. And so Thomas Isaac, of course, is on the front lines of it all. And Thomas, you've just released a new book, yes. And it just happens to be about UNDRIP, which was one of the most recent cases that caught people's attention. So let's start there. What do you think about this, the importance of this last court case that threw out the idea of the way we're doing mining claims because it didn't live up to UNDRIP?
So the Court of Appeal decision looked at the legislation that the government of British Columbia put in place, including 2 years after that legislation. This is the DRIPA legislation, Declaration on Rights of Indigenous Peoples Act. 2 years later, then Attorney General David Eby put forward an amendment to the Interpretation Act so that if there was any doubt about what the DRIPA legislation meant, that it was clear that every statute and regulation in BC was to be construed as being consistent with
And he made,
UNDRIP.
As Attorney General, he put in the word must.
Must, absolutely. And look, my reading of the Court of Appeal decision, I do want to be clear, this is specific to British Columbia because of the way our legislation dealing with the Declaration of Rights of Indigenous Peoples Act is drafted. Remember, UNDRIP, the UN Declaration on the Rights of Indigenous Peoples, is attached to that legislation. That's a non-binding international document, not intended to ever be implemented into any domestic law by design. And then we had the Interpretation Act amendment, and I think what you see the Court of Appeal, I'll just sort of state it very simply, but I think this is accurate, is saying, government, we're not doing your dirty work for you. The legislation is quite clear. I disagree with Premier Eby that there's that the Court of Appeal was completely wrong in its interpretation. I said it before the Interpretation Act was amended. I said the day that legislation was enacted, and I've been quoted in a number of newspapers, if you go back 5 years, I said it was my view that the government of British Columbia was in breach of that legislation on the day it was enacted. Because, and I'll be very clear, it is impossible to read every statute in British Columbia consistent with all 70 paragraphs of the non-binding UN declaration. You wouldn't have a governable province if you were to do that seriously. And I think what you see the Court of Appeal doing is calling the government out, going, you did it. And they say it's paragraph 199. The court, in its own way, I'm being a bit more colloquial about it, but the court says, look, the legislature chose, it's a word, something to this effect, the legislature chose to put in place a complex, multifaceted international document into domestic law. Live with it. That's essentially what the court said. It's hard to argue with that based on a plain reading. Forget about being a lawyer. I mean, anybody reading the act would have to come to the same conclusion, in my view.
And so Premier Eby, his conclusion is that, well, the courts are overreaching, and I'll just change the wording. Is any of that possible?
Well, I think, first of all, yeah, you can amend or repeal the act. But in this particular instance, I don't think that's accurate. I think what the court did was read what the BC statute says, what the BC politicians, remember, they've been saying two things out of the one mouth. On one hand, UNDRIP was not supposed to mean anything. On the other hand, we are the world leaders charging ahead on reconciliation, and look what we're doing. We're incorporating UNDRIP into, well, which one is it? And so now I think going forward, yes, the government could amend DRIPA and the Interpretation Act. It could also repeal them. My concern, and again, this is just based on the evidence that I've seen, is that over really in the past number of decades, our governments in British Columbia are not prone to taking advice, both internally and externally. I have lots of anecdotal stories internally of advice being expressly rejected internally on DRIPA, let alone all the criticism and concerns expressed publicly or quasi-publicly, and all of it was ignored. And so my concern about an amendment, Carole, is that I don't know if it's fair to say I don't trust them, but they don't have a great track record of taking counsel. And so I'm more inclined to say might be better to take a breather. Let's put UNDRIP on the shelf for a few years and get reconciliation back on track so we can get all First Nations and Métis in this province reconciled, not just 20 or 30. And that requires a robust economy and all sorts of other stuff to happen. But that's the concern I have, is that they don't seem to take counsel. Well, they don't take counsel. It's quite clear.
So how would you put it on hold or pause for a couple of years? Would he need the legislature to pass that?
Yeah, and I think, and I don't think that's an anti-UNDRIP comment. I mean, the book that you cited with my colleague Grace Wu, we're not anti-UNDRIP at all. Quite frankly, I think UNDRIP, especially in those countries that don't have the world's best legal protection of Indigenous rights like Canada does, UNDRIP can play a very healthy role. But, I've got news for everyone. The standard globally in protecting Indigenous rights is Canada and our legal regime, not UNDRIP. And that is a matter of fact. And so I just think that we need to get to a more honest dialogue, and that may sound a bit naive, but I think that's where we need to go with this, and trying to fiddle around the edges, and particularly with the poor track record of taking advice and concerns seriously on an array of issues, protecting private property rights, the Haida Agreement, land use planning, watershed, the forestry sector. I would not be prone to giving them another shot, because I don't think that they've demonstrated a great track record.
Just personally, I can't believe they would actually go back to the legislature and ask to put DRIPA on hold. I just can't see that happening. And if it does stand, I was thinking of all the other bills it would affect. Like, look at Bill 15, which gave government the right to just push through major projects and, don't worry about all of the consultations and everything. Well, that would go out the window, wouldn't it?
Well, Carole, the imposition of the DRIPA Act combined with the interpretation provision, and what the Court of Appeal has said so clearly, is that every statute, every word in every statute, every regulation must now be viewed through the lens of all 70 paragraphs of UNDRIP. That's just a very simplistic notion of what I put on the table. When you look at the BC legislation itself, I mean, I've put on 3-hour seminars on this. So I'll give you just one little example for your viewers. In the BC legislation, we also say we're going to respect all the distinct cultures of each First Nation. Now that's good. We should be respecting the distinctiveness. Challenge is we got 200 plus First Nations and the Métis. So if you mean it, if you actually mean what you wrote, in addition to the 70, every piece of legislation, every regulation, all 70 paragraphs of UNDRIP that use different language than our legal regime, on top of that, you have to consider the distinct cultures and traditions of all 200 plus Indigenous nations in this province. I mean, it gets to the point of it's silly. That can't be done. It's a complete breakdown of an ability to govern. And so I think we need a period of reflection in this province of what do we want to be when we grow up, and where are we going, and how are we going to get there, and how are we going to afford it? And this, I think, becomes the much bigger question.
And so we'll deal with a couple of those questions after we take a short break. Back in a moment. I do wonder if we've reached a turning point here, because there's just been such a, as the Vancouver Sun said, the land claims are piling up all over the province. And so people are hearing, well, this court case went this way and this court case went that way, and what does it mean for my private property? You and I had a conversation right after Cowichan came out, and it was, better be careful what this is saying. Well, now we've had some time to think about it and reflect on it. The Cowichan decision, if it's allowed to stand at the Supreme Court, what does that mean for Canada?
Well, yeah, I mean, if it were to be upheld, I think that's where we left off our last interview. It would be disastrous and fatal to the Canadian economy. If we remember what the decision said, the court is actually quite express on this point, that the Land Title Act does not apply on land where Aboriginal title has been found. Okay? That means the entirety of that act. That act contains the core elements of what we call indefeasible title. The title that no one, it's evidence to the world that that landowner owns the land. Again, I don't know if most people understand how our economy works. It's not just for the landowners, the renters that happen to be watching. Understand that our entire economy is based on the concept of private property ownership. And the idea, I've heard a few people say, well, maybe it'll just be another government recognizing the title. No, it needs to be a public, democratically elected government using the same language that every other Western economy and all the rest of the other provinces use, which is indefeasible title. We can talk about everything else. We can talk about other remedies. So, for example, compensation from the Crown. But this notion of undermining indefeasible title, I don't believe it'll be upheld. Putting aside my legal background and what I do for my day job, I just don't think economically, there's no scenario where I can see that being upheld, because the consequences would be catastrophic for Canada.
And even where it's sitting now, it's, you and I talked about hypothetically, it'd be difficult for a private property owner to maybe get a mortgage at the same rate or whatever. Well, it's no longer hypothetical, because we have examples in Richmond of a big industrial company that had their financing pulled by a bank because of what's going on. And this isn't going to end soon.
No, I mean, we've seen a significant softening in the market, and there's a multiplicity of factors. This doesn't help, and then when you combine that with the UNDRIP decision, and I think I would hope that the current government can reflect on this and say, gee, maybe this isn't working. maybe the approach that we've been taking to date is starting to backfire in a very material way. But yeah, no, it's affecting real people and their ability to move property. We've got to get back to some core basics, and indefeasible title's not on the table. That's got to be a starting point. Having the First Nation, I know Cowichan has said they don't want folks' private property. My focus is not on Cowichan or any other First Nation. It's almost irrelevant because it's the threat of taking the private property and the ability at law to take the private property. And so that lands squarely back at government, not the courts. The Eby government could have done all sorts of things in September. They could have enacted a piece of legislation that said the granting of fee simple interest is a justifiable infringement. That's completely within the toolkit allowable under Section 35. I would call that a pro-reconciliation piece of legislation if they did it.
Why didn't he?
Premier Eby's government could have asked the Chief Justice to call a case management conference so that by the end of September of 2025, there was an order in place so that we could move to an appeal on an expedited basis. As far as I am aware, no such request has been made. And certainly, what is it now, almost 6 months, I guess, since the decision.
And when will
There's nothing. We don't even have an order yet. And, just you look at the timing and you go, the earliest now, one would think you could get in for a hearing, unless the government has a game plan now, all of a sudden to start expediting things, which I genuinely hope they do, but we've already lost 6 months, is the fall of this year. But, that could easily slip into 27 before we even have a hearing.
And so this is going to be a few years before there's a resolution, if it's allowed to just work its way through the courts to the Supreme Court. Tell me how this is affected by the New Brunswick judge, who he actually ruled in the opposite direction.
Well, there you see it's the New Brunswick Court of Appeal, so it's an appellate level, the most senior court in New Brunswick. I'm familiar with that case, but what I would say is that it was primarily a technical issue, that once the lower court found that private parties weren't proper parties to the litigation, that is to say, they weren't the right parties to be going after land. Their land had to follow them. And so the court didn't directly address the very issue we're dealing with in Cowichan. Now, they did in some other statements in the judgment. The Court of Appeal went on to say, you can't, essentially you can't be touching people's private property. That isn't reconciliation, something I've been saying for 20 years. So that's helpful, I think, to hear that. It's not surprising. I think most people, I've got lots of Indigenous friends and leaders I talk to, none of them want people's private property that I know. There might be the odd one out there that does, but if you're asking for Aboriginal title instead of damages, what we see in the Cowichan decision, they got what they asked for. They got Aboriginal title, and that's the right to the land.
Well, and adding to the confusion, we have some First Nations suing other First Nations because there are overlapping claims. And even in the Cowichan case, the Musqueam Tsawwassen, I believe it is, are both, they're trying to get that overturned.
Right.
Because they say, well, it's not all Cowichan land.
Yeah, and again, it goes back to a theme that we talked about before. In fact, I saw a video clip of me from 10 years ago, actually going on 11 years ago, actual evidence of me saying this. We need a game plan in this province of how are we going to get from where we are today to having all 200 plus nations plus the Métis reconciled in this province in an affordable, reasonable manner. And the course that we are on right now not only affects private land owners and industry and our economy and our healthcare and our education, but understand that there are many First Nations. The majority of First Nations in this province are being left behind, which may surprise a lot of people to have me say that. But this, I call it the first past the post reconciliation model that seems to be in vogue in this province. We need to get back to the basics of treaty making. Apples to apples, you constitutionally protect a treaty. As a lawyer, that can give us certainty if it's drafted properly. But these side agreements, the Haida agreement and that, they do not give us legal certainty. They don't. They just don't. And Premier Eby and others can look in the camera all they want and say how much certainty they provided. They don't. I'm a practicing lawyer. I know hundreds of lawyers in British Columbia, and that does not provide additional legal certainty to doing business and doing transactions.
So why do we think when Premier Eby was part of speaking against this ruling before the ruling came down, so now he's going to appeal, why do you think he'll do a better job at the next level of government?
Oh, I don't know about that. I believe it or not, I am trying to stay out a bit of the politics of it and just I just look at the evidence, and I would say that, my money wouldn't be on an about-face change. I mean, as an observer of all this, I do sense a bit of smugness out of the government. We know better. We don't need to take counsel. We don't need to take advice. Doesn't matter how many concerns we hear. We are going to force feed this. Now, British Columbia's been going down, I've said this before and I'll say it again. It's not just the current provincial government. This has been building over 3 decades in this province. So we are where we are.
And on that note, we'll see where we're going. Thank you, Thomas, again for being so clear in this analysis of a pretty confusing topic.
Thank you, Carole.
We'll be back in a sec. We now have the courts, our legislature, First Nations, private property owners, and businesses in a tangled mix of uncertainties. Will Cowichan be upheld by the Supreme Court? Can the Interpretation Act on DRIPA be adjusted so that our elected officials control the implementation and pace of reconciliation rather than judges? Let me know your thoughts on YouTube. Till next time, I'm Carole Taylor.